Hello everyone, I think we are live. So, hope you all are doing well. If you can just tell me that you can see me and there is no problem with the audio and the visual and you can get my voice. Good evening. Good evening all of you and welcome to RostrumLegal. So just 1 minute more and then we'll be starting with the class. Alright. So since it is a regular class as well as the live class for many of you, so I would try to keep it as simple as possible. And secondly, I'm trying to use the basic means which we generally use in our classroom teaching, this whiteboard and marker. So that you can have this entire feeling of that you are having a proper offline class. First thing. Second thing, uh, after today's discussion, my idea is that you should be knowing about 5 things in relation to the first topic, or I have tried to actually culminate so many topics together and to provide you in one go so that you can just have a quick revision with respect to the upcoming exams, whatever you have. Okay? So, any problem with the language, like I would be using Hindi in between. So, like you people are okay with Hindi English mixed language, or you only want me to be in English, so you just need to let me know in the comment section. So, please try to focus over here. I'll try to finish as much topic as possible in this short span of time. And for tomorrow, I have planned something else. All right? Take care. So, everyone is ready? Right? And let me tell you one thing. This course is not free, although it has been said that it is a free course, but this is not free at all because at the end of the course, you definitely have to give in your comments, you have to give your likes, and also subscribe to the channel, note that this Rostrum Legal portal, so that whenever we are online and whenever we are running such courses, so you people get notified about it and get to learn. So let's learn together, all right? And let's begin the class for today. So my idea today is to tell you about that why we study law of tort. What is the significance of law of tort? So that is the first thing that we would be dealing with. All right. The second thing that we would talk about is that what is actually tort and law of tort. हम कई बार confused रहते हैं. Like if you have seen, I have put up the heading as tort or torts. Why I did so? Because I wanted to emphasize over here that there are two theories related to tort, basically, which talks about that whether it's a law of tort or law of torts. Fine. The third thing that I would be discussing with you today is that what are the constituent elements, basically, which define that generally there is no, specific definition of tort as such, but then still we need to understand that what are those ingredients or what are those constituent elements that need to be present in order to arise a tortious liability. All right, we cannot say that a person can be made liable for everything under sun. So there has to have some ingredients or some elements which need to be present so that we can verify that yes, the tortious liability arises. So that is why we will be talking about constituent elements. Fine. The fourth thing is that we'll be talking about what are the remedies which are available in the law of tort. And finally, I'll be talking about defenses. So I presume that this is not something, very new and you must have already read in your law LLB in college and university. And this is a very common subject which is being taught at the first year and the second year. But yeah, sometimes we do find it boring, but I really find it interesting because I really find this subject has a lot of significance in the present context that we are living right now, and even earlier for that matter. All right, so शुरू करते हैं. ठीक है? Now, why do we need to study law of tort? The very first thing, we need to study it definitely आपका सबसे पहले जवाब आएगा. The answer will be we have to study it for the purpose of exam. Yes, you have to study it for the purpose of exam. But definitely, if we think from the jurisprudential point of view or the jurisprudential essence of the law of tort, all right. So we are living in a civilized society. Okay. And in a civilized society, because we know that this is a new discipline, this evolved as a new discipline, it is not a new discipline anymore. So this evolved as a new discipline. And when it evolved as a new subject, it tried to bring in the recognition of the rights, along with it, the recognition of the obligations and the duties of the people. Because we know, right, we have learned, we have also studied in so many ways that a right has a corresponding duty. So we cannot just talk about rights in a society without realizing the fact that you also have equally responsible duty towards the other person. So when we start thinking in this perspective, the society becomes a better place to live in. Now, many a time, a question is being raised that if this law is so much important, then why it is not codified? So there the beauty of law of tort lies basically. Right. This is not codified because there can be in many ways the tortious liability arises. There cannot be just one way in which you can arise the tortious liability. There can be n number of ways in which you can arise the tortious liability. So it's very difficult to actually, codify each and every tort. All right. So that is why the idea is that the law of tort being an uncodified statute, which is commonly based on the common law and the judicial precedents, tries to evolve as a subject. अब दूसरा interpretation इसका ये भी हो सकता है. You can all easily ask me that amendments are possible, but amendments are not that easy. You also know that. All right. So it was well thought of decision to keep this law of tort, which is commonly based on the common law principles, to keep it as uncodified. Right. So this has to be kept in mind because tortious liability can arise in so many multiple ways, and that we will get to know. And if, now coming to, if you would have limited it to a code or a statute, then it would have been very easy to alter it. Now that is also one of the point, right? So that is the significance of law of tort, that even in a civilized society, we have both the rights and obligations to be fulfilled. So if we have the obligations to be fulfilled, then we have to realize what is the most important obligation? The most important obligation is to realize the corresponding right of the person. Because on what maxim the law of tort is based? So the law of tort is entirely based on the maxim of, if you would have heard, like altrum non lidere. So what is the purpose of law of tort? So the purpose of law of tort is to not hurt anybody by word or deed, right? That makes you responsible, that makes you accountable for your conduct. Okay? आगे चले? So I just write down the maxim over here. It's altrum non lidere. Right? Okay. What does altrum non lidere means? That you are supposed to hurt nobody by word or deed. Fine. Now let's move forward. So what is tort? So tort is, in a very basic term, it's a civil wrong, it's a private wrong. We know that it is not a criminal wrong. And I'm going fast because, we are doing it as a crash course. So you have to be focused over here and just face up with me. So what I'm trying to say is, हमने ये समझ लिया कि why do we study law of tort? Now we are talking about that what is tort. So tort is basically a civil wrong. The first thing that you need to understand is that tort is a civil wrong. All right. Why civil wrong? It is a civil wrong because the remedy lies in civil law. You understand the difference between civil and criminal, right? Okay. We also understand that there is a difference with respect to when you seek for remedy in a civil law and a criminal law, and there are different procedures involved into it. So the procedure which is involved in seeking the remedy of law of tort is a civil procedure. So what is law of tort? First, tort is a civil wrong. The first thing. Alright. We also know that it is derived from a Latin term which is tortum. Tortum. Tortum means to tortum means twisted. Tortum means twisted. Alright. That means a conduct which is crooked, a conduct which is twisted, a conduct which is not right. What did we discuss earlier? That what is the maxim on which the entire purpose of law of tort is based? The entire purpose of law of tort is based on the maxim altrum non lead re. Now, what is this altrum non lead re? Altrum non lead re simply means that you're not supposed to hurt anybody by word or deed. So, when you say you're not supposed to hurt anybody by word or deed and you perform a crooked conduct or a twisted conduct or a wrongful conduct, then the tortious liability arises. So, that is what you have to understand. So, as I said earlier, that there is no specific definition of law of tort. Alright, there is no specific definition of law of tort, but there are certain definitions which are being provided, like if you see the Limitation Act of 1963, Section 2M of the Limitation Act of 1963, it provides for that tort means a civil wrong which is not exclusively a breach of contract or breach of trust. Okay? So tort kya hai? Tort is a civil wrong according to section 2M of your Limitation Act 1963, which is not exclusively a breach of contract or breach of trust. So what is a breach of contract? So it is a civil wrong, I have already told you. What do you mean by breach of contract? Section 2M of your Limitation Act 1963. Alright, it defines tort. 1963 ka Limitation Act, it says that tort is a civil wrong which is not exclusively a breach of contract or breach of trust. So there are 2-3 things which we can understand from this definition. Number one, I'll just write it down. Can you see this? Section 2M Limitation Act 1963. Section 2M Limitation Act 1963. Alright, so what does it say? It simply says that tort is a civil wrong which is not exclusively a breach of contract or a breach of trust. Now, let's go thoda sa into breach of contract. Now, what is breach of contract? Civil wrong to theek hai, we have understood. What is breach of contract? What is a contract first? An agreement which is enforceable by law. Alright, since it is not a contract class, so I'm not getting into the detail of it. That it is defined, contract is defined as an agreement which is enforceable by law. That is that agreement, jiske breach mein, there is a breach of that agreement, so you can just go and enforce it in the court of law. So that agreement which is enforceable by law is referred to as contract. Alright, what happens? How do you breach that? What are the ways? Now we know that breach can be actual breach and anticipatory breach. We have learned law of contract. We know that breach can be actual breach and anticipatory breach. Now I'm not getting into what is actual and anticipatory. Okay, that can be done in the contract class. Then moving forward, how do you breach the contract? So I always use the acronym breach of contract ke liye FIR. Can you see this? People? FIR. Alright? Those who are my old students, I think I have mentioned this in the class, so they might be knowing it. So, breach of contract means FIR. Right? Kaise? How? Now, F stands for when you fail to perform the obligation in the agreement. So this I just picked up an acronym to make it simpler for you. Whenever you have to write a breach of contract, if you can just remember this acronym, that breach of contract means when you fail to fulfill the obligation in the agreement. So that is one instance of breach of contract. Second, when you make yourself incapable to perform the obligation in the agreement or the contract. Alright? So, whenever you make yourself incapable to perform the obligation in the contract, so that is again a breach of contract. Alright? And third are when you refuse to perform the obligation in the contract or the agreement. You have to keep this thing very clear in your mind that, failure to perform, incapability to perform, and refusal to perform are completely three distinct things. They are not just one and the same thing. Alright? So, this is it. Now, what happens when there is breach of contract? So, the contract gets discharged. Fine. So, we know that tort, now coming back to tort. So, we know that tort is a civil wrong which is not exclusively breach of contract, and it is also not breach of trust. Because what happens in case of trust? So trust is defined in Trust Act 1882, I guess. Okay. So in that case, you repose confidence into the person for the interest of the other person, for the interest of the beneficiary. So benefit lies for somebody else, and it's the other person, the third person, who is getting into the agreement. So tort ना तो contract है, ना तो breach of trust है. So what is tort then? Tort is any twisted or crooked conduct which gives rise to a tortious liability or obligations against you. Now, how this liability arises? How this liability arises? This liability arises because you have a corresponding duty. You have to keep the maxim in the mind. Now, क्या हर समय हम ये liability arise कर सकते हैं? ठीक है? Somebody asked me about the FIR, full form of FIR. So S stands for failure, I stands for incapability to perform, and R stands for refusal to perform. ठीक है? So, can we arise the liability in each and every situation? Is it possible? So what are those constituent elements that arises the tortious liability? Right? So what are those constituent elements or the ingredients? When they will be present, then only we can say that yes, this is a tort. Right? So what is that? Number one, anybody? Can anyone help me out of this? What is that? Whatever your questions are, people, let me first finish it. Then I'll repeat for your benefit at the end. First, whatever I have decided for you all, just be focused and listen to it, and then I'll be taking up all your questions. Fine. Someone who's not able to understand the relationship of twisted with, let me see the question. I think Priya asked that question. She's a student of mine, Priya. All right. So I think the question was, somehow I missed that question. There are so many charts. So I think the question was the relationship of twisted with the maxim. What is the maxim? The maxim is, I repeat, please listen to it carefully. The maxim is altrum non lidere. ठीक है? Clear है? Altrum non lidere. Altrum non lidere का क्या मतलब है? What is the meaning of altrum non lidere? That is to hurt nobody by word or deed. All right. So when I say that you are not supposed to, or I am not supposed to hurt anybody by word or deed, what does that mean? That simply means that my conduct should not be crooked or twisted. So that is how I related to the word, from where the word tort has been derived. Tort has been derived from tortum. Tortum kya hai? Twisted or crooked. How do we relate to maxim? We relate it to maxim in a way that the entire law of tort, depends on this maxim, altrum non lidere. Now, what is altrum non lidere? Again, I repeat, to hurt nobody by word or deed. Now, it was this case of, if you want to just write it down, the case of Jai Lakshmi Salt Works Private Limited versus State of Gujarat. I'll just write it down for you. I'm writing here. It's Jai Lakshmi Salt Works Private Limited versus State of Gujarat. Right? Jai Lakshmi Salt Works Private Limited versus State of Gujarat. All right. So this is a case of 1994. In this particular case only, the significance of this maxim was emphasized. All right. So just for a reference, in case आपके PT में question आ गया, if you get a question in your PT that which is that case which emphasizes the significance of the law of torts. So that is one case, one of the earlier case, Jai Lakshmi Salt Works Private Limited versus State of Gujarat. They can also ask you about the maxim, that what is the meaning of this maxim, or which is that maxim on which the law of tort is based. Clear? Okay, which is the first case in which the word tort was used? Anybody? That case is Bolton versus Hardy, 1597. कई बार पूछ लेते हैं. I'm just writing it down here. Bolton versus, can you see the year? Hardy. 1597. Bolton versus Hardy. 1597 का केस है ये आपका, जब पहली बार ये tort शब्द, the word tort was used. All right. I forgot to mention one thing. I think I'll get it back to that statement once when I am done with this ingredient. So let me first finish with this ingredient and then I'll get back to that statement. All right. Yes. So just to justify this maxim, why I'm focusing so much on this maxim? Because once you understand the purpose of this maxim, you will understand, the entire tortious liability or the tort that we see, either in your syllabus or any book you read. For example, if you just see this maxim, that to hurt nobody by word or deed, and just take the example of strict liability. Now, what does strict liability says? That if you are bringing in a dangerous thing in your compound, and you are performing a non-natural use of that thing, and that escapes out of your control, then whose responsibility it is? It is your responsibility to protect the injury which is being caused to your neighbor. All right. I'm just trying to bring this connect. Try to understand. So, if you see, even the concept of strict liability is based on this. In fact, any tort, आप कोई भी tort उठा लीजिए, it is based on this maxim कि आप कोई भी ऐसा काम नहीं करेंगे जिससे कि आपका conduct ऐसा नहीं होगा which is going to hurt your neighbor. All right. Secondly, if you take absolute liability, which is again based on the same principles, but when we know that it is stricter than strict liability, we'll be talking about it. If you see negligence, what is negligence? You have a duty to take care. And since you had a duty to take care and you did not, take care of the responsibility and the obligation, so there has been a negligent act on your part, so the tortious liability arises. See the example of nervous shock. What is nervous shock? That you are not supposed to perform an act or a conduct which hurts the central nervous system of the person and brings him or her under the shock, because of which the daily affairs of the person is restricted or some injury is caused. I'm not getting into detail of it, just to make you understand. Defamation का example for that matter. That क्या होता है defamation में? You read in your IPC also that you are not supposed to, we have a right to reputation, right? Even under Article 21 of the Constitution. So you cannot just disrespect a person, or you cannot disrepute a person in the eyes of the right-minded thinking person of the society, not in everybody's eyes, because you can't control everybody's thought process. We know that, right? As a mature individual. So, but that thinking or thought process should not be affected in the right-minded thinking person of the society. Okay? So pick up any tort for that matter, and you will nuisance ले लीजिए, malicious prosecution ले लीजिए, false imprisonment ले लीजिए. You will find all these torts to be based on that maxim, that is also non-literate. All right. अब आगे चले, ठीक है? Yes. So I was just talking about that what are the constituent elements which constitute tort. Okay. So what is the first constituent element? The first constituent element is wrongful act or omission. Okay. Wrongful act or omission. Now, what do we mean by wrongful act or omission? क्या मतलब है इसका? Anybody? Anyone from the class? So the first constituent element is that there must be a wrongful act or omission. Okay? What do we mean by wrongful act or omission? I'll be taking up all your questions, and please thoda sa be patient and wait, because you might feel that by the end of the lecture you are not having any questions. So let me go one by one. First, let me explain that what are the constituent elements, and then I'll be talking about the question mark that I have put up. All right. So wrongful act or omission simply means, see, it is talking about that tortious liability will not arise in each and any or every way. There has to have some wrongful act. Now, what is this wrongful act? You can hurt a person either by causing injury to the reputation, or causing injury to the causing injury in person, or causing injury to the property of that person. Okay? There is no dispute with respect to this. So you can hurt a person in either of the three ways, and there can be many more ways. Okay, because this is an evolving discipline and law is a dynamic subject, so we can definitely find out some new tort. All right. So you can hurt a person in either of these three ways. But is it like any hurt or injury will arise a tortious liability? What do we read? अब थोड़ा सा IPC में जाने की कोशिश करते हैं. What do we read under section 95 of IPC? How does this general exception arise? What is section 95 of IPC? It says that if there is any trifling act or trivial act, then it is not to be taken care of. All right. So if there is a trifling act or any trivial act or any social right or moral right or religious right is being hurt, okay, and the person is in pain or injury with respect to that particular right, then no liability arises. The law is only concerned about the violation of a legal right. So whenever there is a violation of a legal right, now it can come in many ways. That legal right can come in many ways. Like either customary rights or the rights which are being recognized or the rights which are being specifically provided through the statute. So it can come in many different ways. Okay? So whenever there is a violation of a legal right, that is considered to be a wrongful act. And it is only when there is a violation of a legal right, all right, that a tortious liability arises, and you can go for a civil action. Now that is a different thing altogether. That prima facie level pay or whether there is any specific injury, that depends on the kinds of tort. उस पे depend करता है. Okay. Now what is omission? Omission means that you had a legal duty. Here you have violated, in case of wrongful act, you have violated a legal right. In case of omission, you had a legal duty and you have not performed that duty and there has been legal omission. So we are not referring to any omission for that matter. Alright? We are referring to a legal omission on the part of the person who is a tortfeasor or who is alleged to be a tortfeasor. Now, who is a tortfeasor? Who violates basically in tort the right of a person, or who basically violates the legal duty which is already provided with, right? And he does not perform the duty. So there has to have one thing: wrongful act or omission. What is wrongful act or omission? That is violation of a legal right. अब इसमें हमें case discuss करते हैं, ठीक है? We discuss a case that is, let me tell you, I'm sure you must have heard it. The famous clock tower case. Anybody remember it? Municipal Corporation Delhi versus Subhagwanti case. That was a case of 1966. What happened in that case? Quickly, I'll tell you about the facts. So there was this clock tower which was almost 40 years old, and no maintenance was being done, and it was on the road. It was in Chandni Chowk in Delhi and near the highway. And then there was a passerby who was just moving on that road, and because of the lack of maintenance and the poor construction, basically some portion of the clock tower, it fell on the person, the deceased, and he died. And then this case is being brought by the wife of the person who is Subhagwanti for compensation in law of tort. So basically it was held, so the municipal corporation claimed that it did not owe, there was no privity of contract. So the municipal corporation claimed that it did not owe any duty towards the deceased. Alright, so no liability, no tortious liability arise. So the court in this particular case said that when you are, controlling or maintaining such buildings and they are being constructed on a highway, so the maintainers of the building have a special responsibility to take care of the situation that nobody gets injured by the building or, because of the non-maintenance or under-maintenance of it, and the passers-by can pass safely and, with all due and care. So this was what was held in this particular case when they claimed that there has been an omission on your part, all right, even if you have not violated the legal right, but then there has been an omission on your part or the legal duty, and that is why the liability arises, all right. Then there is this other case of, I'll be providing you the handouts. Basically, I generally provide the handouts in the class. We do it for regularly for our students. So I'll be giving you the handouts and you can just have a look at it, and all the cases are mentioned over there. And then you can discuss with me later on. Then there is this case of Usha Bain Trivedi versus Bhagya Lakshmi Chitra Mandir, which is a AIR 1978 case. Aapko yaad hoga that Jai Santoshi Ma case. Alright. Now what happened in that case? So basically this case highlights that the legal right is important and not just any social, religious or moral right. So we cannot say that because in that particular movie, so this is a case with respect to Bhagya Lakshmi Chitra Mandir case is related to a movie where the goddesses like Santoshi Ma and other goddesses, they were projected in a way that they are fighting amongst each other. So one of the devotees, she went to the court and she says that this violates my religious feeling and this is against my religious belief, so there should be a ban on this movie. So the court held in this particular case that there is this has violated when she alleged that her rights have been violated. So the court said that the tortious liability arises only in case of violation of the legal right and not just in any case of violation of the social, religious or moral right. So they might ask you in the exam, like, which is this case related to violation of the legal right. So these are the two cases which you can mention, like we can keep in mind, right? ये generally पूछ लेते हैं preliminary में. All right. Okay. You want me to write the name of the case? Wait, I'll write the name of the case. So we're related to wrongful act or omission. So the first case is municipal Corporation Delhi versus Subhagwanti. This is also famously known as clock tower case. All right. Clock tower. अगर आपको पूरा नाम ना भी याद हो, so you can just remember this clock tower case. And this is a case of, let me just check the year. Yes, this is a case of 1966. Okay. Great. I'll just erase this from the board so that I can write the next case. The other case is Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir. Okay. Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir. AIR 1978. Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir, AIR 1978 का ये case है. I think the facts of the case are clear. See, generally, I'll be providing you this handout. This is ready with me, all right, so that you can just have a quick revision before your preliminary exam. But the thing is that, and this will be very helpful in your mains also. So you can just fill in the gaps if you remember. You can run the video and you can see it, and you can just fill in the gaps over here. But for the live students, I need to check because there is a test that will be conducting at the end of the 5 days course. So I'll just coordinate with the team and I'll check that how I can provide you the handouts. I might provide you on that day. So okay, so in this Usha, I'll just repeat. In this Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir, this case, people listen carefully. It emphasizes upon that the tortious liability arises only when there is a violation of legal right and not just any social, moral, or religious right. That is what you have to understand. How? Now, what happened in this case? I told you the facts that this is a case. इसे जय संतोषी माँ case के नाम से भी जानते. So there was this movie जय संतोषी माँ. उसमें जो है the goddesses were projected in a way that they are fighting amongst each other for the superiority. That there is a more superior goddess. And there is this lady who was basically Ushaben Trivedi. She was not happy with the way in which the goddesses were projected. So she said that her religious feeling and sentiments are being heard. So that is why this film should not be brought into public, and there should be a ban on this movie. So that is what Supreme Court held in this particular case. Because itna detail mein jaane ke, I'm not telling you specifically all the facts. Now, because see, law of tort is all about cases. So it's very difficult to remember very categorically. So try to remember, the specific points that has been held in each and every case. So the Supreme Court held in this particular case that we are concerned about the violation of the legal right and not just the social, religious and moral right, because then it will be very difficult because like you see, right, every day this is happening. Padmavat released some religious sentiments gets hurt. OMG releases some religious sentiments gets hurt. There's so many movies religious. Abhi recently, I don't remember, but I don't because I cannot comment upon that how it is. They talked about some Beyonce Sharma, and there is this movie and the song release of that. So I don't know because I'm not following that news, so I cannot comment much on it. But such kind of incidents, because there was this comment with respect to that this is a racist remark. So I have not got into that. I have not researched on that. So I cannot comment it over here, and I will not like to till the time I have researched it. But then you see it on and off. These things are happening. So अगर ये ऐसे होने लगेगा, okay. So what about the creativity and the right to free speech and expression? So freedom of speech and expression will be gone for a toss. So that is why. But yes, freedom of speech and expression, we know that under Article 21 that has to be subject to right to privacy. We have seen in the recent judgments and the cases. So that's another discussion altogether. But in this particular case, it was here that we are concerned about the violation of legal right and not just violation of any social, religious or moral right. बस इतना ही याद रखना है आपको, इससे ज़्यादा नहीं जाना है, ठीक है? Fine. Now let's move forward. I hope you have noted it down, so I'm just raising it. All right. This was about the first constituent element, right? So this was about the first constituent element. Now, what is the second constituent element? The second constituent element which creates a tortious liability is that this wrongful act or omission should have caused legal damage. All right. This wrongful, I'm just putting an arrow over here so that you can understand. So this wrongful act or omission, okay, you're getting my voice? Let me fix the mic. So this wrongful act or omission should have caused legal damage. All right. Now, what is legal damage? What do we mean by legal damage? Right? Anyone? What is legal damage? So legal damage simply means वही जो हमने अभी थोड़ी देर पहले समझा है, violation of legal right. Legal damage simply means violation of legal right. All right. Not just any damage we are talking about. We are talking about the violation of legal right. So I'm not writing it over here because I need some space to write it. So it is violation of legal right. All right. Violation of legal right. Now this violation of legal right, जब भी हम legal damage पढ़ते हैं related to violation of legal right, we understand it along with, like, there are two incidental concepts that we have to read in violation of legal right. Now what is that? We read injuria sine damnum and damnum sine injuria. So what is this violation of legal right known as, what is this violation of legal right known as, people? It is known as injuria. It is known as injuria. Alright? Violation of legal right is known as injuria. Okay? Now there is a very pertinent question which is being raised. Okay? That even if there is no damage being caused, try and understand. Violation of legal right, आप ये समझ लेंगे तो then the cases will be cakewalk for you. Violation of legal right does not mean at all that it has caused some damage, manifested damage, all right, or with physical damage, which is which you can see with your naked eyes, which is manifested, which is at prima facie level, and it can be proved at the prima facie level. So violation of legal right does not mean that कि actually में damage cause होना is necessary, actually में injury cause होना or harm cause होना is necessary. But what is necessary is that you have violated that legal right. All right, even if no damage is being suffered by the person. So that is what we read in Ashby versus White. That is what we read in State of Bhim Singh versus State of Jammu and Kashmir, and that is what we read in Ashrafi Lal versus Municipal Commissioner Agra, and even the Rudal Shah case. All right, we know that in case of Bhim Singh versus State of Jammu and Kashmir, Bhim Singh versus State of Jammu and Kashmir, there were exemplary damages which are being provided. Why? Because what is important is injuria sine damnum. So that is why we do two concepts over here. I'll just please. What is important is injuria sine damnum. Right. So when we talk of legal damage or violation of legal right, so we talk about injuria sine damnum. Okay? That if there is a violation of legal right, for example, if I have a right to vote, I'm taking from the cases only, and then you have these follow-up cases which are being discussed over here. So if I have a right to vote, but I have been imprisoned, or I have been stopped from casting my vote, or I have been stopped from exercising my legal right, so the injuria is being caused to me. Nevertheless, it does not matter that the person for whom I was going to cast my vote has actually won the election. But what is important is that I had a legal right as well as a constitutional right to vote, all right? And I was stopped from voting, and now my right has been violated. It does not matter at all that whether the person has actually won the election or lost the election. You're getting my point? All right. So that is what injuria sine damnum talks about. So it was in the case of, I'll just write down the name of Ashby versus White. Just let me repeat it. It was in the case of Ashby versus White, all right, where it was said that if a person, in very simple terms, I'll bring it to you, if a person has a right, the person must have the means to vindicate those rights. So all the discussion around, if you see, related to policies and programs and legal rights, क्या होता है? What is that general discussion? That yes, you have provided the right, but you have not provided the means to basically recognize those rights and enforce those rights. So what is more important? Important is that not only providing the legal right, it is even more important that you let the person to enforce or exercise that legal right. So you have to provide the person that particular environment. All right. So it doesn't matter. For example, if a person, let's not just talk about right to vote. If a person has a right to food, we are seeing in the COVID times the issue, right? How many people, the migrant laborers issues, and there have been so many issues that people are starving and they're on road. So if they have a right to food under the Constitution and under a particular act, so what is happening? Basically, their legal right is being violated. It is not necessary that they have not died because of the starvation. But what is important is that there might be a question in your mains, related to this aspect. So what you have to think? You have to think from the perspective of that once a legal right is being provided to you, and it is a recognized legal right, then in that particular case, if there is a violation of that legal right, that is injuria, if there is an injuria, then it does not matter that there is no damage. Alright. It does not matter so that there is no damage. So that is why in the case of Ashby versus White, it was held that when a person has a legal right, that person must have the means to vindicate those rights. Otherwise, there is no purpose of providing those rights. Alright. Then we also discuss a next concept over here, that is, अच्छा इससे रिलेटेड एक और चीज बता दो, इसमें बहुत सारे केसेस हैं which they can ask you related to injuria sign damage, like Bhim Singh versus State of Jammu and Kashmir. Again, as I said, that it's there in the handout. Bhim Singh versus State of Jammu and Kashmir. Alright, I need to check the citation, people. So let me see. Then you have this case of Municipal Board of Agra versus Asharfi Lal. There is this another case. Municipal Board of Agra versus Asharfi Lal. Now, what happened in Municipal Board of Agra versus Asharfi Lal? ये यूपी में and even in other states they might ask this question because पूछा होगा I've seen. So in this particular case, the name of the person was wrongfully struck out of the जो election roll होते हैं वहां से, ठीक है? So then he fought for it that why my name is not over there. So that is how he was granted. So the court held that there is a violation of the legal right in this particular case. So his name should have been there in the election roll. So because he has all the right to cast his vote. So that is how he was compensated for that particular incident. So tortious liability arose in that case. Bhim Singh versus State of Jammu and Kashmir. I hope you all know about this case. Bhim Singh versus State of Jammu and Kashmir. Great. Yeah, I forgot to mention the citation. That's 1986. Alright. So what happened in Bhim Singh versus State of Jammu and Kashmir? Anybody? Just in one line, if you can. It's very much related to the Ashby versus White case, right? And we know that in Bhim Singh versus State of Jammu and Kashmir, exemplary damages were provided. Alright. So basically, the petitioner in this particular case, Mr. Bhim Singh, he was a member of Legislative Assembly of Jammu and Kashmir, and he was wrongfully detained, by the police. And thus he was deprived of his legal right to attend the assembly, which was one of his fundamental rights as well. Okay. And in that particular respect, the court, awarded him exemplary damage at that particular time of ₹50,000 as a way of consequential relief in that particular case. Yes. ठीक है? Clear? अब आगे चले. So this is injuria sign damnum. फिर से I'm repeating. What are we trying to focus over here? We learned the first constituent element, that is wrongful act or omission, which is clear. Second, what we are talking about, that this wrongful act or omission should lead to legal damage. Okay? What is legal damage? That is violation of your legal right, that is injuria. that this wrongful act or omission should lead to injuria. Now, in injuria, in violation of, legal damage, we talk about two things: injuria sine damnum and damnum sine injuria. So you might get a question like this, that even in your mains for that matter, you might get a question that even if there is no damage caused, or they might give you a situation, they provide you facts, and even if there is no damage caused, so still there will be a tortious liability. So yes, there is a tortious liability because we are concerned about the violation of legal right, which has already happened. So it does not matter if there is no manifest injury. This has to be kept in mind, and then these are the cases that you need to refer to. But let's move forward. Now, what is damnum sine injuria? Very easy. The next concept is damnum sine injuria. ठीक है? So damnum means damage. Sine means without. And injuria means legal damage. And what is legal damage? We know that is violation of legal right. Okay? So does the tortious liability arise in this case? That there is a damage, alright, but no legal right is being violated. Now, how is this possible? What are those situations in this can actually happen? That there is a damage, but no legal right is being violated. So this is a situation where actually, this it happens when the person against whom you are alleging tortious liability is actually exercising his or her own legal right. Understood? मैं फिर से repeat कर रही हूँ. This is a situation where the person against whom you are alleging tortious liability is actually exercising his or her own legal right. Because if you don't allow, see, if I am exercising my legal right, just take it from a real life example. Okay? If I am exercising my legal right, or if we at RostrumLegal are charging very nominal fees to students, and you all know that, right? So if we are doing that, so what is our purpose? The purpose is to be accessible to the masses, so that the education and at this level, the preparation can be made available to all of you. Whosoever is a deserving student and whosoever is who wants to prepare for the exam. Alright. So the purpose of this free class is to provide accessibility to each and every one of you. Right? But if somebody comes and claims that this is a strategy which should not be allowed, and there is a tortious liability which arises. Because of this, the other person is not able to take care of his or her classes. So will we say that we have violated the legal right of that person? No, we have not. Because what we are doing actually, we are exercising our own legal right. So these kinds of situations, if we don't allow this to happen, if we just accept this plea, then what will happen? The daily life would become very difficult and the complexities of life would not be able to be dealt with, right? Because every day we are in a competitive world, and a highly competitive world. There is no denial to that. So we have to understand that to the extent the person is actually exercising his or her own legal right, there is no violation of the legal right of the person. Because every person has a legal right and you have a corresponding duty to respect that right. Now, yes, definitely, we have to check in so many situations because we cannot go into that. Just wanted to explain you this because I hope there is no monopoly which is being caused. Hope there is no, There is no breach of the competition policies. That is why you had this MRTP Act. That is why you had these competition law, which takes care of all these commercial transactions in the commercial world. So that is why there was this need of bringing in these acts, and so that there can be a fair trade and there can be accessibility and availability of everybody in the market, and there can be a fair competition. I'm not getting over there. बट हाँ, ये आपके दिमाग में क्वेश्चन जरूर अराइज होगा कि ऐसे तो कोई भी कुछ भी कर सकता है नहीं. If we see the current statutes, there are so many laws which prevent these kinds of activities. But then, having said that, this is not a competition law class, so having said that, what we need to understand that if a person is exercising the legal right, if a person is actually, using the legal right, exercise of his or her own legal right, then it will not be, and because of the exercise of that legal right, some damage is caused to the other person, then it won't be said that the person has violated the legal right. So very famously, there is this case of Gloucester Grammar School. I think you must have read this. Exactly. Somebody has, that is why I wanted to take the questions later. Somebody has wrote that, so please, I would request that please stop your personal chat also over here, because, I can see that. Since I just want to reply to one chat which I listened. Since Usha Bain Trivedi was considered to be a case of damnum sine injuria, so that is why no relief was granted. Usha Bain Trivedi is a case which we have discussed in the first point, that is wrongful act or omission, and not in legal damage. So you have to be clear about it. Alright. I did not talk about Usha Bain Trivedi in legal damage. I talked about Usha Bain Trivedi in the case of wrongful act or omission, जहाँ पे हम बात करते हैं कि we are concerned about the violation of legal right and not the any right. Alright, people. So yes, so there is this Gloucester Grammar School of just either 1410. Gloucester Grammar School 1410. ठीक है? So the same thing happened in this particular case, Gloucester Grammar School, which I just told you, that a person actually opened up a school and he started charging very nominal fees, and the students from the other school, which was nearby to that school, to Gloucester Grammar School, they started moving to the new school, which was formed on a nominal fees. Alright, so the person alleged that there is a injuria sine damnum, so there is a violation of my legal right. So in this particular case, it was held that there is no violation of legal right, because the person, it's a fair competition, it's a competitive world, and the person is exercising his right to trade. Alright, so he can actually do whatever he does in a good faith to exercise his right. Okay? Alright, I'll take up your questions, people. Thoda sa sabr. Let me complete, and I'll take up your questions. Fine. So let's move forward then. So this was the second constituent element to arise a tortious liability. Now what is the third? Third is there has to be a legal remedy. There has to be a legal remedy, which is based on the concept of ubi jus ibi remedium. So, if somebody asks you that is ubi jus ibi remedium is a constituent element of tort, yes it is. How? Because you can only provide remedy when there exists a remedy in law of tort. In the sense that it says that if there is a wrongful act or omission, that wrongful act or omission should lead to injuria, that is legal damage, that is violation of legal right. And for that injuria, there should be, there should be a remedy. Now, it's somewhat, fulfilling to each other because they say that there should be a remedy and then they say that this element is based upon the maxim ubi jus ibi remedium. That by default, wherever there is a right, so if you have given a right, that means obviously you're also providing the remedy to the person. So if there is a legal right which is being recognized, then definitely there is a remedy with respect to violation of such rights. All right. So if you can just see this and note it down. Right? I'll just take a sip of water. Just give me 1 minute. So I repeat again that in order to prove a tortious liability, we need to have 3 elements. What are those elements? A wrongful act, number 1. Violation of a legal right, that is injuria, that is legal damage. And third, there has to have a legal remedy. Now we need to see that yahi pe I want to discuss in detail thoda sa, because that is a separate topic altogether, but I want to bring it together here. That what are the legal remedies that are available in tort, and then we will move on to defenses. Okay? So let's understand that what are the legal remedies. इसका मतलब ubi jus ibi remedium का मतलब समझ में आया आपको कि where there is a right, there is a remedy. Clear? Now let's move further. What are the remedies that are available in law of tort? All right. So the remedies are judicial, extrajudicial. Okay, people, focus here, please, because now these days they're asking questions from this area. Basically, they'll ask you what is the nature of the remedy that can be provided, what are the kinds of remedies that can be provided in law of tort. And basically, jitna main aapko bata rahi hu, whatever I am telling you, if you can just keep that in mind and reproduce over there, it's more than enough. All right. So, in case of tortious liability, we can have both kinds of remedies, judicial and extrajudicial, depending upon the tort. All right. Depending upon the tort. Now, what are the judicial remedies? Anybody? Until. Should I rewrite it? Thoda taki, you can. Are you able to see till here? Yahan tak? Are you able to see? If anybody can tell me. If anybody can tell me. No issues. I think you will be able to see. If not, all right. Okay, file this out. Fine. So you're able to see it. Okay. So what are those remedies which are available. Judicial matlab, in law, what is the remedy available to the person whose right has been violated by a tortfeasor? You can try to use this word tortfeasor in your answers when you're writing for main. हालांकि ये preliminary के लिए है and what fast है if you would have been doing it for mains like as I'm doing it for my foundation batch students. Alright, so we are actually dealing it in quite detail. But then just for the crash course thing and for the preliminary point of view, so just even if you remember this much. So when we say judicial, so there are certain remedies in law available in case of violation of right. So, what are those? Number one, damages. Sorry, damages. Number two, injunction. Number three, restitution of property. Clear? Can you see this? Damages, injunction, restitution of property. ठीक है? देख पा रहे हैं ना आप लोग? It's visible, right? All right. But let's deal with them one by one for just 5-7 minutes. I'll not focus much on this. Okay. Damages क्या है? Damages क्या है? They are, just don't get confused with the word, damage and damages. The damages are basically pecuniary compensation. What are damages? Damages are pecuniary compensation. In one word, if somebody asks you, what do you mean by damages? So damages, you can see over there, pecuniary compensation. Okay? This pecuniary compensation is based on the idea of restitutio integrum. आपने पढ़ा होगा. Even in tort, you must have read what is restitutio integrum? That you are trying to restore back the person to the original position. Clear? In simple terms, I don't want to make it complex because there can be so many dimensions and discussions related to damages. Just for this purpose over here, for the purpose of remedy over here. Alright? So, judicial, extrajudicial. Judicial में, we are talking about 3 remedies. What are those remedies? Number 1 remedy is damages. What are damages? Damages are nothing but pecuniary compensation which is being provided to person in order to restore back to the original position so that he can be provided some relief. So it is based on the concept of restitutio integrum. पहले सुना है, right? Restitutio or restitutio, howsoever you want to pronounce it. So restitutio integrum. Alright, that is representation to previous position. Alright. Clear? यहाँ तक clear है? If you want to just, I'm just taking a pause so that you can write it down. If you want to write down. So what is the purpose of damages? The purpose of damages is to provide reparation. Do you want me to write it down on the board or you can just mention it? Pecuniary means related to money only. Alright? As far as here it is concerned, because you can have other, because when you talk of restitution of property, so that can be equal to money worth. So pecuniary, it means related to money only. Clear? Fine. So what is the purpose of damages? The purpose of damages is to provide reparation. That is, bringing back the person to the reparation. Repairs, basically, अगर देखा जाए तो. Reparation. I think ये थोड़ा confusing हो जाएगा. Should I write it? ये देख रहा है ना आपको? नहीं, ये देख नहीं रहा. Let me write it. reparation. If you can just see it over here. That is, you want to repair the position of the person. You want to bring him back to the original position. Okay, and it is based on what? It is based on restituto integram. Alright? Restituto integram. ये दिख रहा है? Restituto integram. ठीक है? Now damages, very quickly, can be of different kinds as well. Right? Because I remember last year or some 2 years back, there was this question on that what are the different kinds of damages. Alright? In some of the exams I have seen it. So damages can be of different kinds. But let me just erase this off so that I can give you in point form. Because remember, Abhi, just a while before we have talked about that Jammu and Kashmir, Bhim Singh versus State of Jammu and Kashmir case mein exemplary damages were provided. That means that exemplary damages hai, the logic goes, that means there are nominal damages as well. Alright? So yahi se hame do kinds samajh mein aa jate hain ki at least two kinds are there, that there can be nominal damages, there can be exemplary damages, and exemplary damages were provided in the case of Bhim Singh versus State of Jammu and Kashmir, even in the Rudra Shah case. Alright? So damages can be, should I just erase this off completely? I'll write it here. Damages, which are pecuniary compensation, its kinds. Alright? So damages can be, number one, contemptuous. Can anybody tell me what do we mean by contemptuous damage? Ordinary, exemplary, alright? Ordinary, exemplary, nominal. Ordinary and nominal just they are like one and the same thing, but just to give you an extra point. You know, and what else? They can be general and special. General and special. Sixth, I'm writing here. They can also be, I've read, continuing. Interesting, right? This word, continuing damages. How? That you will see. Just for 2 minutes. So contemptuous ka matlab? Contemptuous simply means that there was no need to bring in the action. Alright. There was no need to bring in the action. The defendant's action has a moral justification. So that is why, but since moral right का recognition नहीं होता है, ठीक है? So that is why contemptuous damage आपको जो है वो provide कर दिया गया. Okay? Contemptuous damages, sorry, provide कर दिया गया. Ordinary and nominal are just one and the same thing in a way that fairly, fairly it's being provided after all the calculations being done, and then after seeing that kahin contributory negligence to nahi hai, composite negligence to nahi hai, and all these factors are being evaluated, and after this ordinary damages are being provided. What is along with ordinary, I'll take nominal only. Nominal damages ka matlab, nominal damages are provided for the recognition of your legal right, that a legal right exists. So whenever their court has to send a message to the tortfeasor or to the society, so that there is a legal right which is in existence. So in recognition of that legal right, nominal damages are provided. Now, what are exemplary damages? Exemplary damages are to set an example. So in a way, kind of, if you see the nature of the subject, so basically this is a civil law. Okay, in civil law, we don't go punitive. The idea is not to punish. Okay, we understand this thing that in civil law, the idea is not to punish, but rather to to provide recompense or to reparate the aggrieved party. So that is why exemplary damages are for very extraordinary situations. They are not provided just like a daily routine. So that is why they are referred as exemplary. Because the moment you say exemplary, that means you are trying to send a very strict and harsh message, and you are making that law as punitive, which is not the idea of a civil law, because for that purpose we already have a criminal law, right? And the entire statutes are there. Fine. Then we have general and special damage. There is not much difference between the terms. It's just that, how you use them. So special damage might be with respect to certain circumstances if you want to take care of related to that circumstance. So special damage can be provided. Then at the last I wrote that continuing damages. Now what are these continuing damages? Continuing damages means, for example, let me give you an example. That a road accident happened because of a negligent act. So initially the situation was only of hurt, but then later it culminated into I'm just giving you an example. Don't think that, we are going into IPC. But the situation culminated into a grievous hurt situation. The person was on bed for 20 days, more than 20 days. All right. We know for grievous hurt, one of the conditions is that there has to be a 20 days ka scenario. So, and slowly and gradually, the person lost his job, the person lost his relationships, and there were so many continuing losses to the person. Okay, so in keeping in mind, and the case is still pending. There's a list pending. The case is going on. So the matter is still sub judice. All right. So keeping those continuing situations in mind here, the damages can be provided. Okay, आगे चले. So the damages, there can be kinds of damages: contemptuous, ordinary, exemplary, nominal, and general and special damage, and continuing damages as well. Fine. Clear? Okay. So these are the remedies available in law of tort. Now let's quickly come to what are the defenses available in law of tort. Fine. All right. So we are done with, and this is the last leg that we are moving forward to. All right. So we are done with that. Why do we study tort? What is the significance of tort? We are done with what is tort. We are done with what are the constituent elements of tort, the three constituent elements, and we saw the two concepts: injurious and damnum, damnum and injury in the cases. We also studied over here what are the remedies available in law of tort. All right. And then we also talked about, we are going to talk about defenses. But before that reminds me, I think people should have reminded me. I'm so sorry about it. Let me finish the extrajudicial remedies. Can we just continue the class for 10 minutes extra? If you people are okay with it. Like, whatsoever I'm seeking permission from my regular students. So if they can just, the regular RostrumLegal students. But I just want to finish what I have thought for you people today. Right? So tomorrow we can start with negligence. Let's see. Let's see how far we can see. I have to do the other. Not only extrajudicial remedies, I have to do that injunction and also. I told you judicial remedy may. There are three things I told you. One were damages. One was damages. Then second, injunction. Now you know that how many kinds of injunction you have. Okay? You have temporary injunction, you have permanent injunction, you have mandatory injunction. So all these remedies can be sought after. You know the acts which are related to it. Temporary injunction is provided under where? People? Temporary injunction is provided, right? Anybody? Very good. No, temporary injunction is not provided under contract law. Temporary injunction is provided under your civil procedure code. All right. Which order? Order 39. And anywhere else? Go and check एक बार section 94 of your CPC as well. Please, on my request, please do check section 94 of your CPC. Okay, so temporary injunction is provided in your civil procedure code. Whereas permanent injunction and mandatory injunction is provided in your specific relief act. Alright, so I'm not getting into the detail of it. That is for the SR. SRA, I think I have done with my students. Yes, I have done, right? So I've done SRA with them. So temporary injunction under CPC and permanent injunction under your SRA, and there only we deal with mandatory injunction. What is the purpose of injunction? Purpose of injunction is to stay, okay, till the time the matter is being decided, so that the property is not damaged further, or the person is not put at loss further, or there is no breach of contract. So these are certain purposes of injunction. Very quickly, so take it. You know what is injunction. Then, what do we mean by restitution of property? Again, to give back the person the same property. So you try to restitute that property as far as possible. So these are the remedies which are available in, these are the judicial remedies which are available for law of tort. Okay? Now, what are those extrajudicial remedies? Anybody can tell me? The extrajudicial remedies. Just imagine a situation. आपके land पे, on your land, somebody is creating a nuisance in your property or around you. Will you wait for the authorities to come? Or someone has trespassed your property? The trespassing is also a tort. Alright? Trespass केवल property का होता है या person का भी हो सकता है? People? That is a question for you for tomorrow's class. Alright? So extrajudicial remedy में, what are those remedies? Re-entry on land. If somebody has forcefully moved you out of your land, re-entry on land is one of the extrajudicial remedy. You will not wait for the authorities. Alright? You will try to re-enter your land. If somebody has used any illegal force against you and moved you out of your property or land, and definitely then, and you're not supposed to use any excessive force and take law in hands, but definitely you will try to re-enter your land. Alright? And then after that, you can seek remedy in the court of law. Okay? Then what is next? Anybody? अभी मैंने example दिया of the trespass. Can anyone tell me? Expulsion of the trespasser. Expulsion of trespasser. You can expel the trespasser from your property. Okay? You can do that. You can abate nuisance. What is abatement of nuisance? Stopping it. You know that, right? Cutting it short. So for that, you don't need to wait for the authority. You can go to the person and ask him to stop the nuisance. That is what we do in our daily basis, right? And then only we can call saw number and all, and then we ask the police and ask them to stop the music. But पहले हम क्या करते हैं? What do? We first go to the person and ask them to stop the nuisance. All right. And if that does not happen, then we take the course of law. So you can do these things. Recaption of goods, again related to your good, that can be done. All right. So these are certain extrajudicial remedies for which you don't need to wait for the authorities, and you can actually exercise your own will and without taking law in hand and without exercising excessive force. Because do remember, then all those principles, will come over here. Okay? So, आपको ये ध्यान, all those evidentiary principles, you know that Evidence Act, when you have to prove a particular point, it will apply equally in both civil and criminal cases. So I presume and I believe that you know that. All right. So you have to be very clear. So what does court says? That when you come to court, you need to come with clean hands. So when you are seeking equity, you have to do equity as well. So these are certain extrajudicial remedies which you can use and bring to your recourse without waiting for the authorities and without using any unnecessary force. This has to be kept in mind. All right. अब हम चलते हैं defenses की तरफ. I think I'll be able to finish it off. I do not need to extend. Let's see. Let's be hopeful. Because defenses का point बहुत important है, especially the first defense that I'll be talking about, voluntary non-fit injuria. So initially I'll give you all the defenses. ठीक है, मैं यहाँ लिख देती हूँ. उसके बाद then we will talk about specifically voluntary non-fit injuria. All right. So why do we need defenses in law of tort, people? बताइए. Why do we need defenses? Anybody can tell me why do we need defenses? You all are listening, I presume. So as to be excused from liability. Very good. I just read one statement somebody wrote, so as to be excused from liability. First thing, इससे पहले मेरी नजर गई एक question पे. Somebody asked, what is restitution of property? So I do not wanted to go into SRA, but restitution of property simply means recovery of property, restoring back the property. So if you are forcefully dispossessed of your property, whether it's a movable property or it is an immovable property. So if you have read Specific Relief Act, so you know that there is a relief of recovery of property, that is restitution of property, and you can seek that relief over there through the medium of the Specific Relief Act and through following the procedures as provided under your Civil Procedure Code. Now that is a matter of SRA and CPC, so that is why I do not want you to get into that. But just to give you an example, Restitution of property simply means whether it's a movable property or immovable property, the recovery of your property. Okay, somebody wrote to very good. All of you are absolutely right. Thumbs up. Okay? So restitution means that, defenses means that they are like an immunity to the liability. Immunity to liability. दिख रहा है? Can you see this? Immunity to liability. All right. Can you see this? Immunity to liability. Clear? So these are like immunity which is provided to the tortfeasor. ऐसा तो होगा नहीं that whenever you go with a plea or a plaint, it is only you who would be listened and not the other party. So when the other party brings in the written statement, you know that, in CPC when we talk about the procedure, so the plaintiff goes with the plaint and the defendant goes with the written statement. So the defendant with the written statement will try to bring in some defenses. हालांकि सारे defenses reveal नहीं किए जाते हैं written statement में. They are completely based on facts because your pleading are only related to facts. This has to be kept in mind. Now this is another discussion on procedural aspects that we follow in plaint and written statement. उसके लिए we can have a class sometime later. अभी that is not the area of concern over here. So just you have to understand that whenever the defendant bring in the pleading, okay? So uski pleading mein he would be taking certain defenses to protect himself or herself against the tortious liability that has been alleged against the defendant, which immunes that tortfeasor, the alleged tortfeasor, towards the tortious liability. Clear? Now, what are these defenses? These defenses are, number one, can you just write down or do you want me to write down? Number one, voluntary non-fit injuria. All right. Voluntary non-fit injuria. Chalo, I'll write. My sign here so we can do it. Voluntary non-fit injuria. Now, this voluntary non-fit injuria is also known as defense of consent. ठीक है? क्योंकि यहीं पे आके हमारा सारा डिस्कशन देगा. Defense of consent. The maxim is voluntary non-fit injuria, defense of consent. Then what is the second one? The second one is plaintiff the wrongdoer. Plaintiff the wrongdoer. Plaintiff the wrongdoer. What is the third one? Private defense. Fourth, statutory authority. Statutory authority. All right, can you see this? दिख रहा है आपको? Fifth, act of God. Act of God. ठीक है? मैं आगे कहाँ? I'll erase this here. You can just see. You'll be able to see here, right? ऊपर. Act of God. Sixth point I'm writing here. Necessity. 7. Act causing slight harm. Act causing slight. So sorry, I think my marker is not working properly. I'll get a new one for the tomorrow's class. Necessity, act causing slight harm. What else? Next, inevitable accident. Inevitable accident. Inevitable accident. There's one more. I think that's mistake. That by mistake happening. Mistake. Here, please adjust, people. I'm really sorry for this. So, volatile non-fit injuria, number 1. Number 2, plaintiff the wrongdoer. Okay? Number 3, private defense. 4, statutory authority. 5th, act of God. 6th, necessity. 7th, act causing slight harm. 8th, inevitable accident. And 9th, mistake. So all these are the defenses which can be taken against the alleged tortious liability. Okay? Now let's deal with them one by one. Alright? Hope you people are writing this down. All the live class students, please write it down. Alright? I have to see whether I'll be able to provide you handouts or not, but for your benefit, please write it down. Okay? So let's move forward. I'll first explain it to you. जो बाकी के points है, volatile non-fit injuria हम last में करेंगे बिल्कुल. I'll be doing it at the end. Now, let me explain this one by one. Now, plaintiff the wrongdoer. What does plaintiff the wrongdoer means? Now, plaintiff the wrongdoer basically is a case of contributory negligence. Okay? So, plaintiff the wrongdoer is basically a case of contributory negligence. I'm 100% sure that you must have read in the college, university, that the spring gun case. Okay? Spring gun case. Usme kya tha? That if you yourself, that is a case of Bird versus Holbrook. Okay, I'll just. Should I erase this? Fine. I hope सबने लिख लिया है. So थोड़ा सा मैं इसे erase कर देती हूँ. So in the Bird versus Holbrook case, basically the spring gun case, and basically generally, just to make you even if you don't remember the name of the case, doesn't matter at all. Just remember spring gun case. वैसे Bird versus Holbrook करके अगर पूछ लेंगे, अगर आपको याद रहे तो well and good, nothing like it. Alright. So in this particular case, plaintiff the wrongdoer, what do we try to signify? That we signify that you yourself has committed wrong. Abhi just a while before I told you that when you're going to the court, you have to go with clean hands. So you yourself cannot take law in hand and then you ask the court and go to the court and seek remedy that my lordship, I need justice. So this does not happen this way. So this is a situation of contributory negligence where the person himself is involved in, the plaintiff himself is involved in the wrongful act. So you are trespassing the property of the person. And the other person has put up some spring guns over there, or some ferocious dogs over there, or some electric current over there in the railing, that electric wiring as people do around their land or property in the surroundings to prevent any kind of trespass, so that any miscreants or any antisocial elements or illegal activity may not happen in their property. But there is no notice put up over there with respect to it. कि यहाँ खतरा है, मत आइए, or don't enter my property, or there are ferocious dogs, and it's your responsibility. इस तरह के you must have seen notices in the houses or the land with written over there that enter at your own risk and all these things. All right. So if this happens, and in that process, if the plaintiff gets injured, so the plaintiff cannot say or claim that it was the duty of the defendant to give prior notice because you yourself were trespassing the property of the person. In this context only, I generally discuss in the class just to bring in no relation or connect with you. Section 304A of IPC. बस आपको याद दिलाने के लिए वहां पे एक केस है चेरेबिन ग्रेगरी केस. I request you, please, after the class is over, just go and see the Cherubin Gregory case versus State of Bihar, I guess. You will find it in the comment section only. It's related to the death caused by negligence and it's the same facts जो मैंने अभी आपके साथ discuss किया है. It's having the same facts and they might ask you not in preliminary but they might ask you in mains in दोनों facts को relate करके. Now how you deal with it, for that we will be meeting up next time. All right. I just wanted to refer that please along with this point, go and see section 304A IPC में comment section में there is this case of Cherubin Gregory, State of Bihar. In State of Bihar. Just cross check it, please. All right. So if the plaintiff himself or herself is the wrongdoer, then there is a defense available with the tort feature. Okay. Then what is the next point? What was the next point I told you? Private defense. Okay. Whatever, I don't remember the sequence since I have erased it. So private defense, again, if a person is doing some act in private defense, so it falls under general exceptions. Okay. So it falls under general exceptions if you go through section 105 of your Indian Evidence Act, जहाँ पे burden of proof होता है. Okay, so you can just read that section as well with respect to this Indian Evidence Act ka section 105. So if a person is basically doing causing some injury with respect to in exercise of the private defense, then again that is a defense which is available to the tortfeasor, alleged tortfeasor. All right. Then what next? Next is your necessity. All right. So what is necessity? Necessity, we read in IPC also and here also. What is necessity? It is based on which maxim? This necessity defense is based on the maxim of salus populi suprema lex. All right. I think everybody must have heard it. Salus populi suprema lex. What is salus populi suprema lex? That the welfare of the people is paramount. It is the welfare of the people which should be kept in mind first. So, agar to avoid a larger evil, a greater evil, a smaller evil has been done or twisted conduct has been done, or crooked conduct has been done. For example, if to safeguard the life of like 1 lakh people or 10,000 people, if 2 people have got injured or an injury has been caused to them, then in that particular case, this is a case of necessity and this is also a defense which can be taken by the tortfeasor. And mind you, this is a defense. This does not mean that he is going to be proved non-guilty. You have to keep this thing in mind. These are the defenses which are available to him that the person can take. Whether the guilt is being proved or not, or the person is made liable or not, that is altogether the discretion of the court and it will be decided in the court proceedings and in the trial. But this is the defense which can be taken by the alleged tortfeasor in the pleading. Okay? अब आगे चलिए. What is act causing slight harm? Act causing slight harm is simply that if there is an act which has which is very trifling, which is very trivial, that is section, जैसा हम पढ़ते हैं, section 95 of your IPC. I would have read those sections with you, but there is this paucity of time. So that is why I'm quoting the section. Please go and read it. But section 95 of IPC, please, okay, along with act causing slight harm. So this is how you revise and correlate and interrelate the subjects. So if there is an act which is causing very slight harm, and it is a trivial act, it is a trifling act, so then this is a defense which is available to the alleged tortfeasor, and he can say is that whatever the plaintiff is seeking is in relation to a very trivial act, in relation to a very trifling act, which the court should not take notice of. And then the court decides that whether this is a trifling act or not, and on the basis of it, it will be decided that whether the defense stands or not. Clear? Then what next? Inevitable accident. Now there might be certain situations. All right, there might be certain situations where it is actually very difficult to avoid the accident, and you can take this situation in relation to the point of necessity. So I have just a simple request that whenever you write, like not for preliminary purpose, but whenever you write your answer in the mails, tort bar. So what you can do is you can always clap point number 6 and point number 8, and you can just increase the length of your answer and you can write them together if you're writing on the defenses of the tortious liability. Clear? So inevitable accident are those situations where the accident could not have been avoided and by any precautions being taken. All right. For example, all the precautions were being taken while there was this gas delivery happening, and still because we are dealing with such a dangerous substance, so there is all the possibility that there might be an explosion and the explosion happened. So even in spite of all the precautions being taken, and because of the nature of the work, so in these situations, we basically focus on the nature of the work, that what is the nature of the work is being involved. Clear? Then any act that is done by mistake. Now when we talk of mistake, we also talk mistake of law or mistake of fact. Okay? So definitely if it is mistake of law, then ignorantia juris non excusat. You know that, right? You know this maxim that ignorantia juris non excusat. Sorry. So if there is a mistake of law, then it cannot be taken as a defense. But in mistake of fact, it can be seen under certain situations. What else? Did I leave anything? Act of God. I think I did not explain act of God. Right? Okay. So what is act of God? Whenever we talk of act of God, halaki, we will be doing it in tomorrow's discussion. Either I'll start with liability or I'll do negligence. But whenever we talk of act of God, we have to keep two things in mind. First, that there is no human intervention involved, and it's an involvement of the natural force. Okay? And second, that involvement of the natural force is so extraordinary in nature that it could not have been prevented. All right. So it's not just any seasonal rainfall or storm or weather changes that we face in India, because we know that India is a land of different weather. There are so many seasons and weathers, and there are festivals and customs related to it which we feel on the daily basis. So I'm not talking from that perspective. So any act where there is no human intervention involved, first thing. Second, the act has the involvement of the natural forces, and that involvement of the natural forces is so extraordinary in nature that it cannot be prevented by any human intervention. That has to be kept in mind when we are talking about act of God. Clear? Okay? Now, so that act of God can be taken as a defense, because when the plaintiff goes to the court and says that some injury has been caused, then the defendant can say that, this was an act of God. For example, I don't know whether this is a right forum to discuss this. We can have an economy class discussion. But then, for example, I was talking to my weekend batch of students, and there I gave this example that if today in the COVID-19 situation, the COVID pandemic situation, if people whose rights are being violated, their right to job is being violated, their right to food is being violated, their right to travel is being violated, right to assemble is being violated, and all these. But then, these are national emergencies where we have to take, though not a declared national emergency, but an undeclared national emergency, which we are working under right now. So if somebody goes to the court and says that there has been injuria, then in that particular case, recently, can the government, I'm just throwing this question on you, that can the government take this defense of that the COVID-19 pandemic has been an act of God, when we have so many theories related to it, that yesterday only there was a statement from the virologist that this might be something that has come out of lab, all right? Or the economy is crumbling because of the act of God. So can the defense minister of this country take this defense while defending the central government? So this is something which you need to think about. Thoda sa alag hatke. So I don't want to get into the much of the discussion over here and then talk about GST and all. That is a separate discussion altogether. But then you have to keep in mind that what do we mean by act of God? So act of God simply means that no human intervention, natural forces involved, and the natural force is at extraordinary level. Clear? All right. Now, let's move to the next. And I'm stretching the class, people, with your permission, if you allow me. Can we stretch thoda sa? Can we stretch the class? I think we can. I do not want to. All right. So let's talk about volatile non-fit injuria, because it's really important from your preliminary perspective. So I'll be dealing with volatile non-fit injuria, and that's the end of the discussion for today. And then we meet tomorrow. Right? So what is this defense of consent? What is this defense of consent? Defense of consent is voluntary non-fit injuria, जिसे हम defense of consent भी बोलते हैं. We also refer it as defense of consent. You just don't get confused, because once you understand the words, they might ask you with this, defense of consent and not voluntary non-fit injuria, because everybody knows what is voluntary non-fit injuria. So what does this maxim mean? This maxim simply means that if you have given your consent voluntarily for a particular act, all right? So this maxim simply means that if you have given your consent voluntarily for a particular act, and then after that, later on, some injury is caused, all right? So you cannot cry out that there has been violation of legal right. See, clear? In as simple terms as possible. कि अगर आपने स्वेच्छापूर्वक अपनी इच्छा से voluntarily, if you have consented for a particular conduct, then you cannot say that there has been injuria. यहीं पे confusion दूर कर देती हूँ, because I know there will be straight away a question that means person can consent for anything and no liability will arise. No. When we are talking about a consent, we are not talking about a consent for any illegal activity. So illegal consent is an exception to the maxim of voluntary non-fit injuria. You have to keep this thing in mind, that illegal consent is a exception to the maxim voluntary non-fit injuria. So we are not saying that you give consent for anything and you just immune yourself from the liability. No, it does not happen this way. When we are talking about this, we are talking with respect to some legal right. Okay? And you have actually given your consent to violate those, not violate, basically you yourself are involved in those conduct of that particular act. For example, you have given a consent to the person to Let's take the example of a surgeon, medical surgeon, that you have given a consent to a medical surgeon to operate on you. All right, to operate on you. For example, let's not, these are very old examples जहाँ पे वो कहते हैं कि you have given a consent to the medical surgeon to operate on your left eye. So once you know there is so much of pain, and then you actually don't get the sight back in spite of all the better equipments and the better methodologies being followed. So, can you say that there has been a tortious liability? No, you cannot say, because you voluntarily give your consent, and there can be situations in medical, emergencies where such things can happen. For example, vaccine की बात हो रही है in the COVID trial of the vaccine, all right? Then, and if some allergy or some aftermath or something happens, okay, which is the fallout of the execution of that vaccine upon your body, then you cannot say that there is a violation of the legal right, because you have voluntarily consented on it. But this does not mean, again an exception to the maxim. This does not mean that the person can act in negligence. So again, negligence is one of the exception to this maxim of voluntary non-fit injuria. तो मैं ये साथ साथ लेकर चल रही हूँ so that you understand, because वो ऐसे ही पूछते हैं, because this is how you are asked questions in exam, that you gave consent, but consent does not mean illegal consent. Fine, you are involved in a conduct, but conduct does not mean that the person who has to administer that conduct on you will be performing the act negligently. So negligence is again an exception to voluntary non-fit injuria. All right. So that means when I have given you the consent to operate upon my left eye, you cannot operate my right eye. When I have given you the consent to operate in a proper paraphernalia, in the situation where there is a proper laboratory and proper operational theatre, you cannot operate me when there is no light and there is no experienced medical practitioner or a surgeon. Okay, so these are certain situations which we come across on daily basis, and that is how we can talk about tort. So ये तो example था to explain it. Now, when you say consent, so the consent has two things that you have to remember. Right? Consent has to have two things. All right. Number one, the consent has to be a free consent. The consent has to be a free consent. First thing. And second thing, we discuss the aspect of knowledge, that is sign type, non-fit injuria. So when you say consent, all right, defense of consent. So consent does not has to be any consent. It has to be a free consent. जैसे कि हम Indian Contract Act में पढ़ते हैं 1872, that when it is a free consent, when there is no coercion, undue influence, fraud, misrepresentation, mistake. All right, and when it is free from all these malices, so then it is a free consent. Then only you can say that the person was agreeing upon the same thing in the same sense. So there was consensus ad idem. You cannot say by exercising undue influence or coercion or fraud or misrepresenting the fact, or by mistake the person has agreed to certain thing. So that consent is not a valid defense. That's what you have to keep in mind. First thing. For example, इसमें हम एक case discuss करते हैं. Let me give you the name of the case. R versus Williams case. It's a very old case, right? Where the music teacher obtained the consent by fraud at the pretext of, operating the throat of the minor girl, and then rape was committed upon her. So R versus Williams case, generally, it's in your university syllabus and in your colleges, we are taught with this particular case, and they do refer R versus William case is asked in the preliminary as well as in the mains exam. So no, you must know this name, R versus Williams, in the defense of consent. That there the consent was obtained by fraud. So that is not a free consent, and it is only the free consent which is a valid defense. Okay? Now let's come to knowledge part. Right? What is this knowledge part? So knowledge part means that, there can be a situation, just imagine a situation where a person can say that, this person has freely consented, there was no coercion, undue influence, fraud, misrepresentation, mistake practiced upon this person, and that is why if in the exercise of a particular conduct, if some injury is caused to that person, the person cannot cry out foul. All right. But we have to and cannot claim damages, cannot go for the compensation or any relief, or cannot say that the person who has been exercising that conduct has been negligent in their conduct. But we have to remember one thing very clearly over here, people, that mere knowledge is not enough. All right. Mere knowledge is not enough. Mere knowledge that you are involved in a conduct and you have given a free consent for it is not enough. There has to have, I always use an acronym. You must be knowing that movie. There has to have PA. PA movie yaad hai? There has to have this for knowledge. What is that? Perception. Perception. All right. After perception, appreciation. And then what next? Acceptance. Okay? So this is that not only knowledge is enough, knowledge of that particular act or the knowledge related to what is going to be the consequence of this particular act is enough. It is not enough. What is enough? That the person who has suffered injury or injuria, must have perceived it in the same manner which was actually perceived by the tortfeasor. So there has to have a perception, and we perceive through our sensory organs, right? So we have 5 sensory organs. Don't go into the intuitive level, the 6th one. So we are talking about at the sensory level, all right, that the person was able to perceive the situation. After perceiving the situation, after the perception, the person was able to appreciate that situation in his or her own interest. ठीक है, हमने perceive कर लिया, देख लिया, महसूस कर लिया. Now I am able to appreciate it and form a rational judgment related to it. You understand? Okay? So you were able to appreciate that. So there was this appreciation of the fact as we appreciate the evidences. So there was this appreciation of the fact. And finally, after perception and appreciation, there was acceptance to face that particular injury. Now you get my point? All right? You get the point? So there has to have a perception, there has to have an appreciation, and finally, after you have appreciated the fact, you need to have acceptance. Clear? And once all these things are involved into your knowledge, then only you can say that the entire element of defense of consent is fulfilled. So mere knowledge is not enough. So that is why this maxim, sign type, which means knowledge, sign type non fit injuria. All right, mere knowledge is not enough. There has to have perception of the injury to be caused. There has to have the appreciation of that injury to be caused. And after appreciation, there has to have the acceptance with the free consent, which leads to this defense. And only when all this is fulfilled, then it can be said that you can take the defense of consent. For example, there's a very landmark judgment and a famous case that we refer to in this particular case, जिसे हम stone quarrying case भी कहते हैं. Stone quarrying case, Smith versus Charles Baker case. All right, let me write it down for you. And this is the last for today. Free consent के लिए I gave you the case of R versus Williams, and this is Smith versus knowledge में. Smith versus Charles Baker's and Sons. Famously known as stone quarry. Stone quarry case. It is a case of 1891. All right. Stone quarrying case के नाम से भी इसे जानते हैं. It's a case of 1891. Now, what happened in this case? I'll quickly tell you the fact. What happened in this case was that there was this man who was working as a laborer at a labor site, and there was this stone cutting operation going on through the drilling machines, and he was working on the drilling machines, big huge stones they used to cut. Okay, and then those stones were being transferred with the help of crane from one place to the other place. So while he was into that drilling operation, he was not alarmed for it. One of the stone, it fell on him, and he just, he got injured severely. So in this particular case, the defense which was taken by the tortfeasor were that he had the knowledge of the situation, that what is the nature of the job, and since he has consented for it after knowing the nature of the job, after having knowledge, so no liability arises. So in this particular case, the court held that being an employer, you have the responsibility to guard your employees and inform them before such operations are taking place. So you cannot act negligently and say that just because the person was aware of the fact, so the person is not liable for any kind of compensation. You also have to appreciate this fact that whether there was any perception of the fact, after perception whether there was appreciation of the fact, and after the appreciation whether there is the acceptance to that level that the person is ready to face the danger to that extent. So that readiness to face the danger to that extent is important. So that is why mere knowledge is not enough. Fine. Fine. So we are done with, again, and yes, what are the exceptions to it? So I gave you two exceptions. One is illegal consent. Second is negligence. That just because I have consented does not mean that you will operate in any which way, on your whims and caprice as you want to. That is also not possible. All right. What are the other exceptions? Rescue case. Now, I don't think I'll be able to continue rescue case with you because I don't want to rush in a hurry. So tomorrow class, I'll be starting with you from the negligence wala point, like what are the exceptions to the maxims of voluntary non-quick injuria. I'll be starting with it, and then I'll try to deal with the entire concept of liability, because we have no fault liability, we have no fault liability, we do strict and absolute liability, then we have vicarious liability concept. So it's quite a big topic, and I'll try to bring in all the topics together, and we will be discussing tomorrow. ठीक है? So कल करते हैं ऐसे. It will be too much today. And as I told you that this is not a free class, so you definitely need to subscribe to RostrumLegal so that whenever we are online and you get intimated any which way, we will be sending the messages. But still, you get the notification, because we are going to have so many crash courses, because now it's that exam time is just has started. So let's see, hopefully that we are able to help you out in some way or the other. Please comment, share, and like as much as possible. And that is how we can get connected. So thank you so much, all of you. It was pleasure learning together. So let's meet for tomorrow's class at the same time at RostrumLegal. Right? God bless.